Welcome to Design Domination, where you'll gain confidence, clarity, and a competitive edge in a crowded marketplace so you can dominate your competition. Hi, and thanks for tuning in. I'm Colleen Grotzer, and in this episode of Design Domination, I have yet more website accessibility overlay news for you. Stick around to find out how this affects you as a web designer or developer. Now, in case you haven't heard my numerous rants about overlays and you're not familiar with what an overlay is, it's what some call a widget that works at the browser level to purportedly make a website more accessible. You've probably seen one of those circular icons in the bottom corner of a web page. Now, if you click it, a menu opens up with all of these options that look so wonderful and are really totally unnecessary if the site is actually accessible. Okay, but that's an overlay. And overlays are typically promoted as this easy solution for accessibility by installing a line of JavaScript code. Well, there's been a lot of divide in the accessibility space when it comes to overlays. For instance, many accessibility specialists, including myself, have spoken out against them, most notably in the overlay fact sheet, which has been signed by almost 950 accessibility advocates and is just one of many resources that states no overlay product on the market can cause a website to become fully compliant with any existing accessibility standard and therefore cannot eliminate legal risk. There's also been a lot of drama in this space as well. Several overlay companies have tried to silence overlay opponents in the past, some even taking legal action against those individuals. One example is Facility, a French overlay company. They actually sued Julie Moynat, a French web developer, for defamation. And then they also went after a French digital accessibility firm called Kona after seeing their tweets about the overlay. So it's interesting, I'll leave it at that, to see that the tables have started turning for some overlay companies. I recently talked about the FTC fining Accessiby $1 million for deceptive claims. Be sure to check out that episode for the details on that case. But this newest one has yet another website overlay company in hot water, and that is UserWay. This particular lawsuit is a class action suit that was filed in July 2024. And I don't know why I'm only just finding out about this, by the way. But anyway, the plaintiff is Bloomsybox.com LLC, and they're based out of Miami, Florida. They sell and deliver flowers throughout 15 cities in the United States and then in 5 countries. Okay, and then the defendant is UserWay. Now, you may also remember that UserWay was bought out by Level Access in 2023. I talked about that too. Well, Level Access is a reputable accessibility provider, and they used to speak out against overlays. So it was shocking, to say the least, when they bought an overlay company. Now, UserWay offers 3 plans. They have one at $490 per year for up to 100,000 page views per month. They have another one at $1,490 per year for up to 1 million page views per month. And then they have custom pricing for larger websites. Their website also states that all plans include their attorney-led litigation support program. Now, I don't know if that was on there at the time of this lawsuit, but it's there now. UserWay claims their overlay is in use on 247,000 websites. Okay, so here's what happened. Bloomsybox decided to update their website in 2023. And as part of that, they researched accessibility providers and they decided on the UserWay overlay. And they did that because it was marketed as a one-stop solution. And they promised compliance and avoidance of lawsuits, even legal support of $1 million in coverage in case of a lawsuit. Well, after only 6 months of having the overlay installed on their website, Bloomsybox was served with paperwork about a class action lawsuit. Bloomsybox then approached UserWay about this, and they said, well, you're on a monthly subscription, and you need to be on the annual one to get the legal support. So that same day, Bloomsybox decided to go ahead and pay for the annual plan. Well, UserWay then opened up a ticket about this matter, and then they sent Bloomsybox their legal action guide. And that consisted of information about the ADA in general, the law, a summary of the claims of the lawsuit, and something saying that the overlay made the site compliant. It provided absolutely no helpful legal information to Bloomsybox at all. And as if that wasn't a punch in the face, UserWay closed the ticket 4 days later, leaving Bloomsybox hung out to dry. So Bloomsybox took it upon themselves to get an attorney, and that cost them $4,000. Honestly, I'm surprised it didn't cost them more. But they ended up settling a few months later with a monetary payment. Now, Bloomsybox is bringing this lawsuit as a class action suit, and that is so it applies to other customers of this product. One premise of this case, and I'm not a lawyer, so this is just stuff that I'm reading and my interpretation of it, but one premise of this case is deceptive marketing claims. Bloomsy thought that the overlay would make their website accessible and protect them from lawsuits. Well, why did they think this? Well, the complaint states in Clause 8, UserWay advertises that its products will lower and even eliminate the possibility that customers will be sued for ADA violations. UserWay's claims in this regard are false. In fact, businesses that use UserWay's product are more likely to be the target of lawsuits. UserWay also advertised the overlay as a quick and cost-effective solution. Just install a single line of code and the overlay will fix the accessibility issues on the site to conform with WCAG 2.1 AA from day one, and then to continue to monitor and fix things on the site after that as well. Now, Clause 28B of the complaint mentions an FAQ. Does UserWay provide full ADA compliance? And the answer was, yes, UserWay's AI-powered accessibility widget provides full ADA and WCAG 2.1 compliance. So apparently, that answer was edited in December 2023 to say, yes, UserWay's solutions ensure ADA, WCAG 2.1, and 2.2 compliance through our AI-powered accessibility widget. So they omitted the word full, and they added in 2.2 conformance. Okay, now a side note here is that words matter, right? Compliance and conformance are two different things. Be very careful about what you are promising. I covered that in another episode. Regardless, though, UserWay was promising both. And then Clause 34 of the complaint mentions the overlay fact sheet, saying the fact sheet concludes that overlay products like UserWay's do not help visually impaired people access the web, but instead actually hinder their access. The complaint also talks about UserWay's false claims surrounding the legal support in case of a lawsuit. Clause 9 states, as more fully described below, UserWay makes specific and material claims to induce businesses to purchase its widget as an effective alternative to the work required to actually be ADA compliant. Among these inducements is the promise to provide legal support if the business ever faces legal claims that its website does not comply with the ADA. Indeed, UserWay makes the illusory claim that paid subscriptions are backed by a monetary pledge. UserWay's pledge is specifically intended to mislead customers into believing A, that UserWay will reimburse customers up to $1 million in the event of a website accessibility lawsuit, and B, that any customer who has installed UserWay's widget is very unlikely to be named as a defendant in such a lawsuit. In truth, UserWay will only honor its pledge in the event that a case is litigated to a judgment. Of course, as UserWay is keenly aware, website accessibility cases are never litigated to judgment. Attorney's fees, settlement payments, and other costs are not covered. The complaint also mentions that UserWay advertises that the easiest way to avoid lawsuits is to automate your code's remediation with UserWay AI-powered solutions. And then they go on to talk about how the FAQs even included this response to the question, does UserWay provide assistance with demand letters or lawsuits? Yes, luckily you won't need it when running UserWay's AI-powered accessibility widget. I mean, that's so brazen. And then they provide evidence that between June 1st, 2023 and June 1st, 2024, more than 1,000 website accessibility lawsuits were filed in the Southern District of New York alone, and that many of these cases involved websites using UserWay. Instead of providing the legal protection, UserWay tries to get customers to pay more money and for website remediation. As a result of all of what happened here, Bloomsy is going after UserWay on 4 legal points. The first is breach of contract, because customers must agree to UserWay's terms of services, and that is a legally binding contract. So this goes back to what UserWay was promising and didn't deliver on. Bloomsy alleges that UserWay engaged in deceptive practices. Well, because UserWay is headquartered in Delaware, the complaint talks about the violation of the Delaware Consumer Fraud Act, or DCFA. The third involves violation of the Magnuson-Moss Warranty Act, 15 U.S. Code Section 2301. I think I said that right. Bloomsy alleges that UserWay breached its written warranty. They implied that the overlay would do certain things, and it did not. Then the fourth cause of action is negligent misrepresentation. Okay, now in looking up the complaint on pacermonitor.com, which I know nothing about since I'm not a lawyer and I'm not regularly using a website to look up case documents, but it appears that UserWay recently filed a motion to dismiss in February, but I can't find this information anywhere else. So I have no idea if that's the case. Now, I mentioned earlier to stay tuned to find out what this and the Accessibility case mean for web designers and developers, especially if clients come to you and they ask about making their website accessible, or if their website already uses an overlay. But even if they don't, as their web designer or developer, you need to be armed with accurate information to provide your clients as their trusted provider. You need to give them the information that they need to make an informed decision. Overlays alone do not make a site accessible. Overlays do not protect against lawsuits. And maybe you've already told them that using an overlay is okay. And maybe now you're rethinking that and you're not sure how to approach this with them because, you don't want to look bad. That's certainly understandable. But if you don't say something and they don't have all the information, then you're just putting their business at risk and your reputation as well. Give them that information and then it's up to them to make an informed decision. Now, another lesson to be learned here is to be very careful about what you promise when you build a website, accessible or not, right? Make it clear what clients are getting and what you're delivering, whether that's an accessible website, whether it's not. And if it's an accessible website, does it conform to WCAG 2.1 AA? Does it conform to WCAG 2.2 AA or whatever? And be sure to watch out for promising compliance as well. If this was helpful, don't forget to like, share, and subscribe. Support the podcast by buying me a coffee. It might actually end up being a glass of wine or some tea, but you could go to buymeacoffee.com/creativeboost.